Good afternoon, everybody. My name is
Uh,
Jim
uh,
Boyle. Oh,
Jim, I'll cue you up when we're
okay.
ready to go. Okay,
Yeah,
we'll just let some people come in first.
sure.
All right. Well, good afternoon, everyone. My name is Dan Sakaki, and I am the Director of Stakeholder Relations and Membership at the Richmond Chamber of Commerce. Welcome to today's Lunch and Learn webinar, Changes to the Unionization Process, What BC Employers Need to Know, presented by fellow members, Forte Workplace Law. Before we begin, we'd like to acknowledge that the Richmond Chamber of Commerce operates on the traditional territory of the Musqueam First Nation. They have lived on this land for millennia, and we are grateful that we can gather here today. All right, just some housekeeping duties. Everyone will be on mute during the presentation, and we are encouraging questions today for the Q&A at the end of the meeting, so please submit them using the Q&A function during the presentation on the bottom of your screen. So we are going to end by 1 p.m. today, but before then, we will get to as many questions as we can. And if you run into any problems during the presentation, please reach out via the chat function. All right, we have some excited members in the room. So now that those housekeeping items are out of the way, let's introduce our presenters for today's webinar. So the main presenter today is Jim Boyle. And Jim is a labor and employment lawyer with Forte Workplace Law. Jim regularly assists both employers and unions in navigating labor law and resolving workplace disputes. Jim brings a pragmatic approach to advising clients in order to achieve outcomes that best facilitate long-term workplace stability and minimize unnecessary industrial disputes. Jim also practices employment law in non-union workplace settings, as well as workplace human rights law. Also joining us today is Jim Wu. Jim prides himself to be a problem solver and is a relationship mender. I love that word, relationship mender, who is keen on putting out fires arising from various stages of an employment relationship, from hiring to firing and everything in between. In addition to having conducted 6 trials within the last 2 years on wrongful dismissal cases, Jim is also very familiar with the administration of employment insurance benefits, as he has adjudicated over 10,000 EI claims during his 4 years working as an EI adjudicator. With that said, let's turn things over to Jim Boyle. Go ahead, Jim.
Thank you very much, Dan, for that introduction. Good afternoon, everybody. I would say it's nice to see everybody today, but obviously this format does not permit us to be face-to-face. I'm sure that I will see many of you at some point in advance in the future, and I'll look forward to that. So today's presentation, as Dan pointed out, is intended to provide a bit of an introduction to primarily non-union employers about changes to union certification rules in British Columbia, and also provide a bit of an introduction to what does a union certification drive and process look like, and once you get that union certification application, what is going to happen from there, what can you as an employer do, and frankly, more importantly, what can't you do? And then we will conclude with a bit of a discussion about some strategies you as an employer might take proactively before there might be rumblings of unionization occurring in your workplace, in order to ensure that employees are engaged and reduce the potential likelihood of a successful union drive if that is a goal of your organization. So I've got a deck set up here, and I'll be roughly following as I go along. I expect this presentation will take somewhere between 30 and 40 minutes, and hopefully we'll leave plenty of time at the end for your questions, which I look forward to. So just introduce you to the Forte Workplace Law labor team, and I put this slide up partially just to prove that not everybody at our firm is named Jim, notwithstanding the 2 Jims who are on the call right now. So our office is located in Surrey. I work primarily out of my home office downtown, which is where I'm located right now. As you can see, it's a bit of an office/jam space. So that's what I do. Our team is made up of myself, Jim Boyle, Sarah Forte, who is the founder of Forte Workplace Law, our colleague Jesse Hadley, who practices labor law in Alberta, primarily on the union side, as well as my two junior lawyer colleagues, Sarah Ewart and Harmeet Sarai. If you ever have any labor law issues, you can always reach out to any one of us and we'd be happy to help. And just to clarify, as Dan pointed out at the beginning, I'm a labor and employment lawyer, which means that I do a lot of focusing on unionized workplace issues, but I also assist non-union workplaces in resolving disputes, drafting employment agreements, policies, and things of that nature. So I'd like to give a bit of an overview just to frame what we're discussing today. So as I said at the outset, this presentation is primarily directed towards currently non-union employers, although I think that some employers who currently have bargaining units and unions in place might benefit from some of this as well. And the idea is to give you a bit of an orientation to what exactly is labor law, what does it mean when a union gets involved in your workplace, what does the process look like by which they actually get those representational rights, and help pave the way for thinking about the prospect of unionization and giving you a roadmap for what to do if you inevitably get a union certification application. As you'll sort of learn in this presentation, the process is very, very fast. Once a union submits an application, they will be likely certified within days of that application. So it can be a bit of a lightning round shock for employers, and hopefully this presentation will give you a bit of a way to ease into that process with a bit firmer understanding of what's happening. So very high level, when I'm talking about labor law, what I'm talking about is all the law that is governed by the British Columbia Labor Relations Code. And I'll just take a step back, and some of you may already know this, but just so we're clear, the Labor Relations Code is not the same as the British Columbia Employment Standards Act. They're two separate pieces of legislation that achieve separate things. The Employment Standards Act is the legislation that sets out the basic minimum terms and conditions of employment for employees in British Columbia. So things like the minimum wage, overtime thresholds, termination, basic termination entitlements, vacation entitlements, things like that are all set out in the Employment Standards Act, and employers need to adhere to at least those basic minimum amounts. The Labor Relations Code, by contrast, is not a piece of minimum standards legislation for employees. What the Labor Relations Code does is it governs the relationship between unions and employers, as well as employees' rights vis-a-vis unions in that sort of tripartite relationship that is formed. So the Labor Relations Code doesn't set out, for the most part, basic terms and conditions of employment. And in fact, for the most part, the Employment Standards Act continues to apply in a unionized workplace, subject to some exceptions that allow you to bargain for certain employment standards terms, provided the terms you bargain are meet or exceed the employment standards amounts. So the Labor Relations Code, as it says on the screen here, it governs the relationship between employers and trade unions. It includes union certification, which is the subject of our talk today. It also governs how to conduct collective bargaining once a union is certified, dispute resolution of disputes under a collective agreement. So, ensuring that there is a process for referring those disputes to binding arbitration. And it also governs things like decertification. So if unions or union members become dissatisfied with their union, there are mechanisms for those members to effectively get rid of the union as well. So just so we're clear, a union can obtain representational rights for employees in your workplace one of two ways. They can either be certified by the board, which again is what we're talking about today, or those rights can be recognized by the employer voluntarily under a voluntary recognition agreement. I'm not going to be talking about that today. By far, the most common way that unions obtain representational rights is by certification. And in most cases, the union doesn't really have a lot of benefit from entering into a voluntary agreement, but just be aware that there are some unions that don't have a board certification and they still enjoy the same rights under the code. Now, again, a certified and voluntarily recognized union has sole authority to bargain and enforce the terms and conditions of employment for employees in the bargaining unit. So again, at a very, very high level, if you have a union that is certified to represent employees in a bargaining unit, the employer no longer has the ability to negotiate directly with employees. All negotiations are with the union. You negotiate a collective agreement. The collective agreement governs the terms and conditions for all of those employees in the bargaining unit, and the union is the party that is responsible for enforcing those rights in the collective agreement by bringing grievances against the employer and representing employees. So basically, it interposes the union in between the employer and its employees. Frankly, that is one of the reasons that employers sometimes are not so keen to have a union come into their workplace. Some employers feel like, they want to continue running their business as they see fit, and they might think that they do a good job addressing the concerns of their employees, and the union might get in the way of that. But the reality is that once the union has those rights, the employer is going to be dealing primarily with the union in terms of employment conditions. So this presentation was spurred by a recent change to the the Labor Relations Code to change the way that certification occurs. And probably the best way to illustrate what the change means is by looking at what was in place immediately before June of this year. So what we're talking about here is two different ways for a union to obtain certification from the BC Labor Relations Board, which again is the body that regulates the unionization and certain labor relations codes issues in British Columbia. BC is a funny jurisdiction because it has gone back and forth several times over the past several years, several decades, between two ways of a union getting certified. Either a one-step system, which is what is in place right now, or a two-step system, which is what was in place before June of this year. So under the two-step system, a trade union would need to sign up at least 45% of employees in a proposed bargaining unit by having them sign membership cards. And once the union reached the 45% threshold, the union was then able to apply to the Labor Relations Board for certification. When the application was made, whether they had 45% or 55% or 60% or 100% of employees in the bargaining unit signing the cards, the next step would be for the Labor Relations Board to order a vote by secret ballot for those employees. So basically what it would mean is that the union files an application, the employer receives the application, the employer is fully aware that the union is attempting to organize and get certified for a bunch of employees in the bargaining unit. But then there was a period of time between the application being received and the date on which the vote would be held. And during that period of time, sometimes employees could change their mind. It allowed the employer to put out certain, and as we'll discuss, very limited and very circumscribed communications to employees to express its views. And sometimes those communications could potentially have an impact on employees' choices. So what you would see sometimes is that the union would bring a certification application and it would ultimately go to a vote, but the union would lose on the vote. And part of the reasoning, it could be, as we'll discuss a bit later as well, that certain employees might have signed on to union cards, but when it comes time to express their opinion in secret, their actual opinion might not reflect what they did when they signed the union card, potentially due to social pressure and things of that nature. But the sort of point here is that there was no automatic certification. It would always have gone to a vote. Employers were aware of the campaign before the certification was finalized, and then employers had some ability to make some communications to employees before the employees were tasked with finally making up their mind. Now, what we have by contrast right now is a one-step certification system. And it's a bit of a misnomer, and I'll explain why. So the threshold support that the union requires to make a certification application in the first place remains at 45%. Okay, so 45% of employees in a proposed bargaining unit sign a union membership card. That allows the union to make an application to the board, attaching those cards or copies of those cards, and let the board evaluate that there's the threshold support has been met. Now, if 45% to 55% or less than 55% of employees in the bargaining unit have signed cards, then the board will still hold a vote. So it will still be the classic two-step system. But the key change that came into effect in June of this year is that if the union is able to sign up 55% or more of the employees in the proposed bargaining unit, then the union can make the application with those cards. And when it goes to the board, and the board checks cards, they verify everything, the board is able to automatically certify the union without going to a vote. So what this means in practice is that if the union is able to get basically 10% more support than they would otherwise require for the threshold, the union is able to make an application that will result in certification based on employees expressing their opinions, in some cases before the employer is even aware the union was organizing. It basically means the difference that the old system, employer receives the application, becomes aware of organizing, and then there's a couple of days before the decision is made. In this case, when the application is received, provided it's all in order, it's too late. There's nothing the employer can do, even if the employer was to go to employees and express opinions, and we'll get into, again, foreshadowing a lot here, we'll get into what the employer can and can't say. But even if the employer was able to exercise some communications with the employees, it wouldn't matter because they've already signed the card. So it's done and dusted on the day the application has been made. So just a couple notes on technical requirements for the cards. This is a bit of dry stuff, but just so you're aware, the stuff that the Labor Relations Board will be looking at is, for the membership cards, is that they've got to be signed and dated by the employees. And importantly, those cards, once signed, are generally only good for the purpose of a certification application for a period of 6 months. The cards, the membership evidence either has to have been signed within a 6-month period, or alternatively, there has to be evidence from the union that an employee who is a member has been consistently paying dues, between the time they signed up and up to the date of the certification application. In practice, most unions are going to bring the application based on cards within 6 months, because in most industries and most newly organized workplaces, the union will say to the employees something along the lines of, you don't have to pay dues until, well, at least until we're certified, but often until a new collective agreement is in place. So most of the organizing activity and the getting the cards signed will happen within a 6-month window. And frankly, in practice, it's usually a much shorter period than that. We're talking about a period of weeks or maybe a couple of months in many cases. They're often quite fast and furious campaigns in a number of industries. And just a quick other technical requirement, membership cards have to have the statement that's on the screen at the bottom that acknowledges that the employee understands the union intends to apply to be certified as a bargaining agent and to represent the employee in collective bargaining. Now, I've brought this stuff to your attention, but frankly, there's the most important part of the information here is the 6-month time window, just because it gives you an idea of what we're looking at by way of, if you hear of union activity in the workplace, you can sort of expect that it's going to be a very circumscribed period of time before you might actually get an application. The reality is, on an application to the board, you as the employer are not generally entitled to review the cards. Those are for the board to review and make its own inquiries. So what ends up happening is that the application comes in and the board will say, we have reviewed and we're satisfied that everything is in order, and you don't get to know who signed a card and who did not sign a card. Okay, so you have no idea who supports the union and who does not. And as we'll get into, you're not allowed to ask your employees either. Quick note on why the government made this change. So, the sort of background to this is, we currently have an NDP government in place, and the NDP, as many of you will recall, campaigned on a fairly union-friendly and pro-labor platform, coming in and promoting the idea of unionization as a benefit to workers, right? That's part of their general platform. And so following through on that platform, in 2018, the Ministry of Labor appointed a panel of special advisors to review the Labor Relations Code, and a report was released in 2019 with a number of findings and recommendations. One of the findings was that the panel had a number of concerns about employer interference in the union certification process. There were concerns that under the previous system, which allowed for two-step certification, a longer time frame between the date of an application and the vote being held, and less restrictions on employer speech during a certification campaign. There were concerns that employers were getting involved and exercising influence or pressure on employees that was exploitative of the economic imbalance between the employer and the employee, and led to a lower rate of unionization. And the concern from the panel's point of view is less around lower rates generally because rates of unionization are good, and more about a concern that employees were being pressured into not exercising rights or choices they otherwise would have out of concern for their livelihoods, their future at the companies, things like that. So the panel at that time recommended a few changes to the Labor Relations Code, but at that time stopped short of recommending single-step certification or card check. What they said in their 2019 report was that we'll start with shortening the time frame between an application being received and a vote being held. I think it used to be about 10 days. Anyway, it went down to 5 days, so a very short period of time, and also tweaked the employer speech permissions under the Labor Relations Code to reduce or restrict what kinds of things the employer was allowed to say to union or to members, to its employees during a union drive. I'll talk a bit about those restrictions in a moment, but basically they really ramped back what it was that employers are allowed to do during a union drive. So those changes were adopted, and the panel had said effectively, well, let's consider putting these into place, and if they don't work, then maybe we'll consider single-step certification. So our current government this year determined that, I've got a quote at the bottom there, which is from a news release from the government, determined that despite the 2019 changes, employer interference and unfair labor practices have continued. So in the government's view, the changes to shortening the time frame for the vote, restricting employer speech, and some other consequential changes were insufficient to tip the balance in favor of employee choice, and they decided that it was necessary to get rid of the two-step system in circumstances where there is some evidence that the majority of employees, in fact, do support the union in advance. Now, just a very brief comment on that political unfolding, and I'll remain neutral in this process because in my practice, I actually represent both employers and unions, so I'm reasonably agnostic to this. But one of the criticisms of this move was that, yes, it is in place, and yes, it will promote unionization, but that is potentially at the cost of employee choice. The people who were critical of this move effectively said, well, there was a democratic process in place. Yes, employers can exert pressure on employees, but so can unions and other co-workers. And by removing the opportunity for employees to express their true feelings by secret ballot, you were leaving some employees in a circumstance where they might have signed on because they felt pressure from colleagues, but otherwise did not want to work in a unionized environment. And now we're taking that away from them. So that was one of the criticisms that was levied at the time. But nevertheless, this is the system that was adopted. And to be very blunt about it, my key takeaway for this change is that this change was a deliberate and calculated attempt to increase unionization rates in British Columbia. It was an attempt to make unionization and those drives a little bit smoother for unions and ostensibly for employees as well who want to exercise their choice free of pressure, and make it more difficult for employers to do anything about it. So when we're going through this, if you are sitting there as an employer thinking this seems stacked against employers, it is, and it is deliberately that way. It was a political choice made by the government. So I just want to talk a little bit about what the logistics of a certification application look like. And the logistics have not changed substantially between the two-step system and the single-step system. But what I'll say is that in terms of, as I pointed out in the last slide, the threshold for support for making an application remains at 45%. And if you get less than 55%, you still do the vote and you do the same stuff as you used to. Most unions are probably going to wait until they have 55% support. So the majority of applications that we will see, and certainly the majority of applications, or actually all applications, frankly, that I have been dealing with or involved in the past, basically since June, have been in respect of single step certification, right? The employers get an application and that application says, there's already support in play, right? The union already has the requisite support. So what usually happens is the union will file the application. A day or two later, the board will sort of vet it, make sure the cards say all the things they need to, look at what the proposed bargaining unit is, et cetera, and then contact the employer and set a hearing date. And usually the hearing date, the certification hearing date, again, these are very tight timelines. It will usually happen within about 2, maybe 3 days of the date that the employer gets notification. So if you're an employer and you've been completely in the dark about this and you've heard no rumblings about union activity, this can be quite a shock. You receive the document and you need to move very quickly to think about how you're going to prepare for the certification hearing, right? And if you have some experience in-house, that means working with whoever your in-house folks are, but it may also mean that if you want to retain legal counsel and get advice, you need to move pretty quickly. And particularly because labor lawyers try to make ourselves available on fairly short notice to assist with these things. Sometimes it's not always possible, so you could be left in a circumstance where you might be shopping around for lawyers for availability for assistance. So I would suggest, just practically speaking, if you get something like this, try and reach out to your counsel if you have them right away, or if you don't, try and reach out to somebody. It could be me, it could be somebody else, but get on that fairly quickly and don't leave it to the last minute. So you might think, well, what's the point of the certification hearing if they've already got 55% support? There's a couple of reasons you will want to attend the hearing. And that's because the work is not necessarily done just because the union has signed up a bunch of people and then says it has 55% support. The purpose of the certification hearing, if you have, if you're going with a single step certification application, is to determine that, well, 2 things. One, whether the union's bargaining unit proposal is appropriate for collective bargaining. So, the group of employees they say is going to form the bargaining unit is a reasonable one to form a bargaining unit. And 2, to discuss inclusions and exclusions from the bargaining unit in terms of which employees should form part of the bargaining unit and which employees should not. So, a couple of notes on the first aspect, so bargaining unit appropriateness. What I mean by that is the board will only certify a proposed bargaining unit for collective agreement if it is an appropriate unit for bargaining. Now, note the legal test is not the most appropriate unit, it just has to be an appropriate unit for bargaining. In some workplaces, that can be very easy to define what that might mean, and in other workplaces it might be very difficult. So for example, if you have a small retail sales operation and all your employees are effectively cashiers, right? They do cash, they do stock, they do various other things. If you have an all-employee unit that just wraps up all those employees, that's probably going to be appropriate. And indeed, the board has a preference for sort of what we call wall-to-wall or all-employee units in many circumstances. It might be more difficult to figure out what is appropriate if you have a very complicated structure where you've got salespeople, you've got administrative staff, you've got warehouse people, you've got manufacturing people, you've got delivery people. That can be a bit more complicated to determine what is appropriate or not for collective bargaining. And the board will consider a number of factors, and this could be the subject of a whole other presentation, so I'll just do it at a very high level. But what the board is considering is whether a rational and defensible line can be drawn around a group of employees such that you can say that group should be subject to a single collective agreement and single collective bargaining regime. And some of the factors that the board will look at in determining that is whether the employees included in the proposed group enjoy a similar community of interest. And that includes factors such as the similarity in working conditions, how they're paid, what their duties are, and things of that nature, the geographic location of the employees, the physical and administrative structure of the employer, and those sorts of factors. So that you can say, yes, these employees are similar enough in scope that it makes sense to bargain for them collectively, right? So, something that would not be a reasonable bargaining unit would be if the union just sort of arbitrarily drew a line around a group of employees and they're sort of mixed and matched, where you've got some office employees but not all of them, and some of the manufacturing employees, but they've excluded a couple of folks who otherwise do the same thing but maybe don't support the union. That wouldn't be rational and defensible, and you as the employer would want to say, well, hang on, wait a minute, why aren't those folks employed or involved in the bargaining unit? Or alternatively, you might say, hang on a second, you've got manufacturing and our on the road salespeople. They are very, very different in what they're doing. Why are they in the same bargaining unit, right? And then you can make arguments about why it is or is not appropriate, right? The second thing that you'll be talking about at the hearing. So again, the union's application will describe what unit they're looking for, which employees they're looking for. And then when the board gives you notice of the certification hearing, they're going to ask for certain information from you as the employer. And usually that information will include a list of all the employees who would be in the proposed unit or at the workplace, their position, their tenure, things of that nature. And usually you will walk through that list of employees and determine whether, certain folks fit that description. If you've determined that this is a unit appropriate for bargaining, are these folks in there folks who fit that description of an employee? And are there reasons they should not be included in any bargaining unit? And there's a couple of reasons why certain employees ought not to be included. So some are statutory. The Labor Relations Code specifically excludes certain types of workers from the ambit of being an employee. And a couple of examples of that are independent contractors. Note, not dependent contractors. So an independent contractor is somebody who is truly external, right? Like you might have an IT person who has their own business and they service a bunch of different companies for IT, and you just engage them occasionally for bit work time to time, but they're not dependent on you, right? Same with the handyman that comes in to fix something at your establishment. A dependent contractor is more like somebody who is contractor in name only, right? So they're technically a contractor, but they come to work, they're dependent on you economically, you're the bulk of their business, and they take direction from you. Those folks could be included in a bargaining unit, even though you have them set up nominally as contractors, okay? Managers are also excluded by statute, and managers are, there's very special sort of meaning of what managers are. They need to actually exercise real managerial authority. So a manager would be somebody who has authority on their own to do things like hiring, firing, discipline, making sort of significant resource or budgetary decisions, coaching employees. It needs to be a step above a merely supervisory employee who might do coaching, but needs to get authorization to make any of those big decisions from above. And then employees who are employed in a confidential labor relations capacity are also excluded. So those would be any labor relations employees you actually have if you're already unionized, but in another environment could also be, human resources professionals, or, if you have a finance person that would be performing the human resources and costing functions during collective bargaining, you could make an argument why those people ought to be excluded because they are assisting management in their labor relations. There's a couple other categories of employees I'll just cover very briefly here. There are some employees that might not be appropriately included because they do not, at the time of the application, have a sufficient continuing interest in any proposed bargaining unit. So, this is a very fact-specific determination, but a couple of examples of employees that might not have a sufficient continuing interest could be employees who are on a long-term leave, who are not likely to return to work anytime in the reasonably foreseeable future. It could be casual employees who are true casual employees. And what I mean by that is employees who are on sort of a roster that they don't work regularly, and you can call them from time to time to offer them a shift, and they have the right under the contract to turn down the shift, right? They don't have to come in and they won't be fired for not coming in. they may or may not have a sufficient continuing interest, and then employees who have given resignation notice before the application was received, because those employees aren't going to stick around. So those are the things you would argue about. Just a quick little note on the sufficient continuing interest piece. It's a bit of a double-edged sword if you want to make those sorts of arguments, particularly when you're looking at a card check system, right? On the one hand, sure, you don't want to have employees in the bargaining unit that really shouldn't be there because it just frustrates the bargaining process. But on the other hand, you don't know who the union has signed up and who they haven't. All you know is they've got 55% support. Now, you can rest assured that the union might, if you are saying, okay, well, we think all these employees ought to be in, and the union says they ought to be out, the union probably has not signed those up. That's just sort of the reality of things, right? Now, it used to be that under the vote system, employers would often want to argue that these categories of employees, the ones on leave and casuals and all that kind of stuff, should not be included. But I would just leave the thought with you. In the circumstances of a card check system, the union has made its application based on employees who have already signed up. You don't know who has signed up, but there's a reasonable chance that folks who are not actually at the workplace with any regularity may not have signed those cards yet, right? So, it's possible that if there are reasonable inclusions to the bargaining unit who should be included, again, like all this needs to be looked at through the framework of an actual sufficient continuing interest, right? So you actually need to evaluate that first and foremost. But if there are folks who do have a sufficient continuing interest and should be in the bargaining unit, and then the board agrees that they should be included and they haven't been signed up, it is possible that the union could fall below the requisite 55% support and open things up to a vote. Frankly, like this as a strategy, it's theoretical, but you're operating based on zero information. So the best strategy is just to go and try and organize things in a way that is logical, complies with the law, and will work best for your business if and when you end up in a collective bargaining relationship. I'm just going to kind of go through a couple of comments on employer rights during certification. And all this is basically to say that there are very, very little of them, right? I'm going to try and wrap this up to leave at least 15 minutes for questions at the end here. So I'll go relatively quickly. Now, as I said, there's very little an employer can do after you've received a certification application. And even beforehand, if you're aware of union organizing activity, you need to be very careful about what you do and say in the workplace. Employees have a right to join a trade union if they wish. That is the employee's right, and the employer has nothing to do with that. It may be your business, but the employees have a statutory right, and that right is very jealously guarded under the Labor Relations Code. So the Labor Relations Code sets out a number of restrictions on what both employers and unions can and can't do generally, but certainly during a union drive. But the bulk of the restrictions, and sort of the heavier restrictions, apply mostly to employers who have a lot of economic capital that they can bring to bear to try and intimidate or incentivize employees not to join a union or to stop being part of a union. So just a bit of a summary, what the Labor Relations Code says you can't do, and some of these are referred to as unfair labor practices. You cannot participate in the interference, formation, or selection or administration of a trade union. So really what that means is that when there's an organizing drive, the employer really can't do anything. You can't tell employees not to join the union. You can't talk to them really much about it at all. You cannot intimidate or coerce employees. So no bribes and no threats, right? So you can't say, if you don't join the union, we'll give you all a raise. You can't say, if you do join the union, we're gonna close down the shop. You can't do any of that. Those are all unfair labor practices. Another thing that you can't really do is just unilaterally increase wages across the board in an attempt to stymie the union, because even if that is not like a bribe or a threat, because it's not a quid pro quo, it may be an issue of participation or interference. So you need to be careful about how you do things. Now, note that you are not prohibited from making decisions that were in the works in advance. These restrictions do not restrict you from continuing to engage in business as usual. So if you have a circumstance where, say a change in terms, a change in benefits provider, an increase in wages, scale back or whatever, was already being planned well in advance, you are allowed to see that plan through to fruition, notwithstanding the fact that there is a union drive-in process. But the proof will be in the pudding, right? You're going to have to go back and say, like, look, this is a process that was underway well in advance of the union's organizing drive. Here's the evidence of our correspondence on this. Here's the minutes from management meetings, et cetera, and here's the culmination of that process. You should be aware of statutory freeze periods where you're not allowed to change terms and conditions of employment either after the certification application has been filed or for a period of 12 months after certification is granted or the earlier of a collective agreement being negotiated. But again, those freeze periods are subject to business as usual, where if you are implementing a change that had already been in the works and is not influenced by an attempt to get the union out of the workplace, you're allowed to continue and make those changes because they're part of the longer chain. I would encourage you very strongly to get legal advice before doing anything like that, because this can be a fairly complicated area of law to parse through. Now, a few quick comments here on employer speech. Employer speech is limited under the Labor Relations Code to statements of fact or opinion reasonably held with respect to the employer's business. Now, I noted before there were changes in 2019. One of the changes was to scale back the employer speech to these opinions and facts reasonably held with respect to your business. It used to say you could comment about unions and things like that. That has been taken off the board. So in terms of what the speech, what is permitted speech, the word business is given a reasonably broad interpretation. And so it can touch on issues that affect your business or issues that affect the statutory regime around collective bargaining. So you are allowed, again, as long as you're not doing it in a way that is coercive or intimidating or anything like that, you are otherwise allowed to make factual or reasonably held statements about current terms and conditions of employment of employees, any crystallized plans for the future. So these are plans that you've already made the decision about and you're going to roll out, right? That can't be plans that are simply being put in place to try and intimidate or coerce employees. You can comment about competitors and market conditions. You can comment about the finances of the business, and you can make accurate statements about, for example, certification requirements under the Labor Relations Code. What you cannot do are things like making general statements about unions or the specific union that is organizing. You can't express your opinion on unions. We don't like unions, or we don't think unions will be good for the business, or anything like that. And you cannot solicit employees to disclose their union support or non-support. Okay, that's for the employees and the union to know, and not for the employer to know. Okay, so severe restrictions, and quite frankly speaking, the old sort of two-step system, what would usually happen is that the employer would receive an application. There'd be a couple-day period before the vote was held, and employers would often scramble to put out some communication to their staff members, right? And navigating these sorts of restrictions. In my view, the communications that would go out, I understand why an employer would want to make sure that they are either setting the record straight or, ensuring they're not sitting by idly while a union organizing campaign is going ahead. But in my view, a lot of the time, those communications are a bit sort of sterile, because your communications are so limited. They basically come out as a statement of facts, and they may in certain workplaces be useful to ensure that employees have all the facts, but in a lot of workplaces, particularly if you have regular communications with employers and have fairly open policies, they don't necessarily add a lot. And in the current circumstances with the single card check system, you can put those sorts of messages out there, and that's totally reasonable. But if you already received that certification application, those employees have already made their decision. So there's not going to be any influencing them in terms of a vote. Just a couple of comments here on employer strategies. So I'll note that union drives are probably most successful where widespread issues of dissatisfaction at work. That could be wages, benefits, including retirement benefits, issues or allegations that there's a culture of harassment or specific instances of harassment that employees don't feel has been dealt with adequately, concerns about health and safety, and that was a big issue during COVID for sure. I'm sure many of your workplaces, there were, big learning curves trying to adjust to COVID life, and probably some employees that were not happy with either some changes or some changes that weren't made. And then circumstances where employees feel like the employer is not adhering to employment standards sufficiently, or in some cases, their employment agreements. Engaged and happy employees are probably less likely to want to join a union. That's not categorically a true statement, but it sort of, I think, makes logical sense that if an employee doesn't feel like a union can do anything to improve their working conditions because they're already pretty happy, they might elect to say, I don't want to dedicate some of my wages towards paying union dues. I'm pretty good. This is a good working place. So as I noted, by the time the union is organizing, and certainly by the time you've received an application for certification, it's sort of too late. Yeah, you can't really do a ton to keep the union out, right? You're not allowed as the employer to make decisions that are tainted by what's called anti-union animus, which is, we made this decision. Yes, it might be good for employees, but really the reason we're doing it is because we don't want the union to come in here, right? That's prohibited under the code. So you want to start as early as possible, and now is a good time to start addressing workplace issues that could lead to dissatisfaction at work. So I've just got here a couple of strategies for you to think about to manage employee engagement and job satisfaction. Things like having an open door policy where employees can bring issues directly to management, having clear policies and practices in place that are consistently enforced. And this is very important because if employees don't understand how things are supposed to work, then they may feel dissatisfied. If they're disciplined, they don't feel like they've had adequate instruction, that can be an issue. And probably most important among that is having clear policies and practices regarding safety and bullying and harassment. And you're actually required in British Columbia to have a written bullying and harassment policy that sets out what bullying and harassment means, says employees are entitled to a workplace free of harassment, and sets a procedure for employees to report the harassment, a procedure for investigating and dealing with it, and for resolving that matter. So having those sorts of things in place and actually applying them will help ensure that employees feel like they're being heard and there are processes in place to take care of them. And again, there's a following through on employee complaints. Whether you agree with them or not is very important. If you can explain to an employee why you've not taken a particular step and it's rational and makes sense, that employee might still feel like at the very least they've been heard rather than their concerns going into a vacuum. And finally, you could consider doing workplace temperature checks, or sometimes what we call workplace assessments, which is when you engage sort of a third party, a human resources firm or otherwise, to come in, design a survey or chat with employees and identify these sort of pressure or pain points so the employer knows exactly on usually an anonymous basis, what are the kinds of issues that are happening in the workplace and then addressing them. And finally, doing competitive research so that you know where your company stands in the marketplace, because employees are looking around, they're seeing what other folks are doing, right? And that includes not just non-union, but also unionized businesses. So, there's an element of keeping up with the Joneses built into this. But, if you are a workplace that is unable to match other businesses in that competitive space, it's sometimes could be worth having, those kind of frank communications to employees that communicate why they might not be getting, whatever deal they're getting at some larger business. And it could be because, you're a smaller business, you're starting up, you're ramping up to get somewhere. There's all sorts of explanations, but quite often having those sorts of, frank dialogues with employees can help make sure that they understand that they're not just getting short shrift. So that's the presentation. I've got about 10 minutes here for questions. So happy to take any of those.
Well, thank you very much, Jim. Very great overview of the amendments to the Labor Relation Code. There's a lot of information there. I really encourage our guests today to post any questions they might have in the Q&A function at the bottom of the screen. You started off, Jim, by saying that this process can be really fast under the new card check system. I think you even used the term lightning fast. Is it possible that under the new system that a union could actually be ratified so quickly that the employer is unaware of the effort until they actually are made aware of the confirmation hearing or the certification hearing?
It could happen, right? Because a lot of union organizing activity is going to take place. Some of it will even take place outside of the workplace. Employees are not supposed to be doing things that are not their job during working hours, so they shouldn't really be, when they're at their desks, messaging back and forth about union activities. But they can do it, after hours. They can do it, on breaks and things like that. And typically, when you have folks who are starting to talk about unions, they will want to do it on a bit of a hush-hush basis, right? For obvious reasons, right? Because, they're fearful of reprisal from the employer. They don't want to sort of stymie the efforts of organizing and being able to select a union. And so a lot of the time, those sorts of discussions will happen without management being aware, quite deliberately. Usually, management will only become aware if either the organizing activity is very obvious, so there's people coming by and leafleting, and you find a leaflet sitting on the floor of the work site or something like that, or an employee tells management, like, just so you know, we've been talking about unionization, just thought you might want to be aware, right? So sometimes that will happen well in advance of a certification application, but certainly I've been aware of some workplaces where an employer is completely blindsided. They've received the application and they had no idea, right? It was just done very, very quietly and without management being alerted. That can be for a number of reasons. It could have been that the organizing activity was just very, very well kept secret, was done very clandestinely. In some cases, it might be reflective of one of the reasons why the union might be coming in the first place. Maybe management is just a bit disconnected from its workers, right? Which is where that employee engagement piece really comes into play.
Awesome, thank you. When I think about unions, oftentimes I think about bigger companies, hundreds or thousands of employees. Recently in the news, there were some workers at 3 private liquor stores in BC who unionized. What typically is the size of a business that's targeted for unionization, and does it depend on industry?
It does depend on industry, and it's a very good question. Unions. So the way that most unions will operate, and just a very quick comment on what a union is. You often think of a union being like Canadian Auto Workers or UFCW or BCGEU or Unite Here, or any of these unions, right? And they're sort of entities that have various locals that go and organize and represent employees at different workplaces. But a union could also just be a group of employees at a workplace who have no affiliation to these entities, who want to organize and collectively bargain with their employer. So with that in mind, it could be any workplace at all. And even these locals, right? They may have mandates where they have certain industries that they would like to try and organize, and they will make a push, right? And so you could have certain industries where the unions themselves might be approaching folks and trying to organize in certain sectors, and it might be easier to do that in maybe larger workplaces. But there's also workplaces where the unionization is driven from within. And so you'll get some folks who are reaching out to unions and making those connections that way, right? And unions are, at least, and maybe I'm speaking out of term, but I'm not familiar with any union that would say, oh, we don't want to organize you because you're too small of a workplace, right? I think that the overarching idea is that most unions support the rights of employees to organize for collective bargaining. And so what that means in practice is that I've seen bargaining units with hundreds of employees, and I've seen bargaining units with fewer than 10 employees, right? It just depends on the nature of the workplace. And at the end of the day, if any group of employees wishes to unionize and can get the support and have a reasonable bargaining unit, they're entitled to do so with the support of a big union or not.
Okay, so that kind of leads to my next question. As we emerge from this pandemic, a lot of our members, our small businesses, mid-sized businesses, they suffered a lot. They went through a lot of hardships, and they obviously incurred a lot of costs and what have you. Cost of dealing with a union could severely affect a business, could potentially run them out of business. Does the Labor Relations Board take that into account on a certification application?
They do not. So the board is not concerned with the economic impact of having a union in place. All the board is concerned with is the very sort of meat and potatoes issues of, does the union have requisite support from the membership? Is it reasonable for collective agreement and or for collective bargaining? And have we addressed the appropriate inclusions and exclusions? So once that decision has been made, the employees are free to unionize and the union will be in place. The economic considerations really only come to bear during, say, collective bargaining, right? An employer might say, well, we actually really have no money to put up here and we're concerned about this. That can be a position that the employer takes of bargaining to argue why it cannot grant, if the union's asking for increases to wages and benefits, the employer might say, we simply can't do it, and can provide some economic data on that basis. But that is not an issue for the board. So unfortunately, if that is the reality for the business, and union is certified as bargaining agent, the employer is going to have to try and work with the union to ensure that they and the employees understand the economic realities and bargain a collective agreement accordingly.
Awesome. So cost is obviously one issue that can affect a business. Obviously, once a union drive, it can cause some tension amongst the staff on either side of the issue. And once the union drive is over, regardless of how it turns out, do you have any best practices for working towards team harmony?
After the union drive is over? It's working towards harmony. Like my practice style is typically to try and work with unions once they're in place. I think that the reality is that sometimes employers can be a bit hesitant. It's a change to their workplace. They're concerned about what the future will hold. But ultimately, when you have a union in place, the employer is no longer going to be solely in control of how employees work in the workplace, right? The employer still has management rights to run its business and make decisions, but it needs to do that within the framework of what has been agreed to in a collective agreement. So it means that in my experience, an employer that wants to continue to fight the union at every step because it's not happy that it is there is, one, potentially going to increase their cost because there's going to be a bunch of disputes that they need to deal with through bargaining or unfair labor practices, complaints to the board, etc. And they're also going to be driving a further wedge between the employer and employees. So I typically try to encourage employers to adopt a bit of a conciliatory stance and to attempt, where possible, to find common ground with the union and build a good relationship with the union to ensure that there's an understanding, things can go smoothly working into the future. That does mean making some concessions as an employer. It frankly will, just about in every case. My view is that it's going to reduce cost and it's going to promote that kind of workplace harmony, where if you're not spending all your time fighting about things and fighting with the union, you might not hear from the union for long periods of time, and you can just focus on having your employees, performing the productive and good work that they have been doing to date. So trying to build a good relationship with the union is part of it. And, part of that means during collective bargaining, listening to their demands, trying to understand where they're coming from and finding those areas of common ground where you can give a little bit, because in my experience, if you give a little bit, you get a lot.
Very well said. Well, thank you very much. We are getting close to 1 o'clock, and I want to make sure I respect everybody's time. So with that said, on behalf of the Richmond Chamber of Commerce, I'd like to thank Jim Wu and Jim Boyle from Forte Workplace Law for sharing their expertise in an easy to understand manner on a very complex issue for all of us in the room today. A reminder that many of our previous webinars are available for viewing on our website's webinar library, and recording of this one will be posted soon as well. So thank you all for joining us today. Thank you, Jim and Jim, and we hope to see you all at a future Richmond Chamber of Commerce event, all of which can be found on our website, www.richmondchamber.ca/events. Have a great day, everybody, and thank you again for joining us.
Thank you.
Thank you.